Luisito G, Pulido vs. People of the Philippines GR number 220149, July 27, 2021. Facts. Arcon, a wife of Pulido who was married with him in a civil wedding at the Municipal Hall of Rosario, Cavite, filed a case of bigamy against Pulido and Balita. Pulido defended that both of his marriage was void ab initio. His marriage with Arcon is void due to lack of marriage license, and his marriage to Balita is also void due to lack of marriage ceremony. Balita, on the other hand, claimed that she only knew Pulido's prior marriage sometime in April 2007 and that she filed a petition to annul their marriage before the filing of the bigamy case. The court even declared their marriage null and void for being bigamous on October 25, 2007. The trial court convicted Pulido of bigamy but acquitted Balita. Appeals and motions of Pulido were likewise denied. The court ruled in reliance with the provision of Article 40 of the Family Code. Meanwhile, in 2015, the court in a civil case declared Arcon and Pulido's marriage null and void. A decree of absolute nullity of their marriage was issued in 2016. Issue: whether or not judicial declaration of nullity of marriage is necessary to establish the invalidity of a void ab initio marriage in a bigamy case. Ruling: no. The court in this case abandons its earlier rulings and hold that a judicial declaration of absolute nullity is not necessary to prove a void ab initio prior and subsequent marriages in a bigamy case. Consequently, a judicial declaration of absolute nullity of the first and/or second marriages presented by the accused in the prosecution for bigamy is a valid defense, irrespective of the time within which they are secured. The court stressed out that the nullity of a void ab initio marriage, being inexistent under the eyes of the law, can be maintained in any proceeding in which the fact of marriage may be material, either direct or collateral, in any civil court between parties at any time, whether before or after death of either or both the spouses. Thus, being inexistent from the beginning, the void first marriage does not qualify nor satisfy one of the essential elements of bigamy, which requires the existence of a prior valid marriage. Logically, there is no first marriage to begin with. As for the retroactive effect of a void ab initio marriage, there is nothing to annul nor dissolve, as the judicial declaration of nullity merely confirms the inexistence of such marriage. This also explains why the second element of bigamy, which requires that the former marriage has not been legally dissolved or annulled, is wanting in the case of void ab initio prior marriage. The RPC provision regarding bigamy pertains to contracting a subsequent marriage when a voidable or valid first marriage is still subsisting. In both instances, the accused may validly raise the defense of a void ab initio marriage without a judicial declaration of nullity. Article 40 of the Family Code requires a judicial declaration of absolute nullity for purposes of remarriage, but not as a defense in bigamy. The court clarifies that the requirement under Art. 40 need not be obtained only for purposes of remarriage. The word solely under Art. 40 qualifies the final judgment declaring such previous marriage void and not for purposes of remarriage. In effect, the judicial declaration of absolute nullity may be invoked in other instances for purposes other than remarriage.